Hi, I'm Lisa Hostetler-Brown. Thanks for joining me for Legally Speaking with LawyerLisa. Today we're going to talk about beneficiaries and beneficiary designations. This is a complex topic, and I'll tell you, I'm just giving you general advice on this. So if you have planning in place, make sure that you consult with your attorney who did your estate planning to get the advice that is specific to you. So let's start with some common things that happen. You can add somebody to an account that you have. So let's say that I own a checking account and I add my friend to my checking account. I hear that's all the rage with the kids these days. You have that person on there, it's now a joint account, and if something happens to you, all of the money in there goes to them when you pass away. If you put in your will that you wanted it to go to somebody else, they don't get it. That beneficiary designation or that joint ownership in this case is going to make sure that that person gets it directly. It only goes through your will if you don't have one of those. Now, there's some risks to this. The person that you put on your account is now a joint owner. So they have full access to the money in there, and they can make withdrawals, and they can withdraw everything in the account. So if it's a situation where it might get dicey in the future, or you're not 100% sure that they would never take any of that money out of there, it might not be the best option for you. Somebody that you have a joint account with is not your fiduciary, so they don't have a certain obligation for you that they would if they were your agent under your power of attorney, or if they were acting as a successor trustee under your trust. So there's definitely more secure ways to do something like this. Another unintended consequence of adding somebody on your account as a joint owner, well, let's talk about a mom and dad who name one of their kids on there. It's their responsible oldest daughter. They put her on their account. She inherits everything when they both pass away, and she's divvying it out to her siblings. Well, those transfers are now subject to gift reporting. And that may not have been the issue when it was originally done, but now it might be an issue. And there could be even tax consequences for doing that. You don't have to file extra paperwork with the IRS, do you? So make sure you're getting good guidance on that. Joint account ownership is not usually my recommendation. You can also add a POD or a TOD on accounts, payable on death or transfer on death, depending on what type of account it is. These are good for bypassing probate, and it'll make sure that whoever you're leaving your stuff to will get it. It doesn't go through your will. But beware, if you have minor children, any family member who has special needs that you're setting up a supplemental needs trust for, or you want to put parameters on what happens to that money if that person passed away, or you want to control how that money is used in the future, a POD or a TOD is not going to be the best option for you. You'll likely want to pass that through a trust. So it's really important that you use the right type of transfer mechanism for your situation. A trust is a great option because it allows you to control what's happening, build in contingencies, and you're not going to have unintended tax consequences. But it's not for everything. Let's take an IRA or a 401k or a 403b for that example. If you have an IRA or another retirement account with qualified funds in it, you're going to want to make sure you're passing that in a tax-efficient way if it's possible and it works for your estate planning. So for most people, that's going to be leaving it to your spouse that has a lifetime stretch for them to be able to take that money out. It helps minimize taxes. Or leaving it to people called designated beneficiaries that can use it over a 10-year period. If you have money that's going to be going into a trust or for minor children, there might be other ways to set this up. And again, your estate planning attorney is going to help you figure out the best, most tax-efficient way to pass this stuff. Then there's other vehicles that you can use to transfer. A life estate deed is one example. Not my favorite. And that would take a lot more than the remaining time that I have to explain to you why I don't like a life estate deed. But if you're using a life estate deed to transfer property, there's sometimes a lot of better options that will help you save money and possibly taxes in the long run. If you're not sure what to do or how to set up your accounts, this is an important part of estate planning. So if you have questions about how your stuff is set up, or it's not set up, you think maybe the way it should be, make sure that you're getting with an attorney right away. We have additional resources on our website that can help you with this. So if you need to know more about the type of account you have and some options for how to set it up, check us out on our website or scan the QR code on your screen. Thanks again for joining me. I'm Lisa Hostetler-Brown, and this is Legally Speaking with Lawyer Lisa. Join us next time.